Hi everyone, welcome to you all, and thanks so much for coming out on a very wet and windy Monday evening to what we are hoping is going to be a really good, practical and useful session on employment law. My name is Clare Sweeney. I've worked with the MDU as a medico-legal advisor for 8 years, and before that I was a GP partner for almost 20 years, so I have lots of personal experience of HR issues arising within general practice. I'm going to start with some housekeeping, if that's okay. So your certificate will be emailed to you within 24 hours, the certificate of attendance. When you leave the webinar tonight, you will get a pop-up screen asking for feedback, and I would ask you just to take a minute to fill that in. It really does help us to target future sessions and actually helped us to plan this session because that's what people were saying that they needed. The questions facility is in the little pop-up box on your screen. We have decided that because HR questions tend to be so targeted and personal and sometimes really difficult to anonymize, that anything about the presentation itself or arising from that, we've decided that it's best that you actually phone the Peninsula helpline, which most of you will have as group care members. If you are phoning the helpline for advice on a specific area that arises from tonight, please have the code MDU 001 to hand, as well as your group care membership number. The questions that we would ask you to put in the chat box or in the question box relate to the benefits of group care membership of the MDU, and Kate Muller, one of our GP liaison managers, is here this evening specifically to answer those questions. So if you have anything that you want to ask about that, please do pop them in the chat. We will have a slide on that at the end, and Kate will have a quick chat with you about what that is. So I'm going to go on to introduce our two experts in employment law tonight. Vicky joined Peninsula in 2016. That's Vicky Kitney. She has a distinction in Level 7 Employment Law from the Chartered Institute and actually won the Employment Law Consultant of the Year in 2020. Before she joined Peninsula, she had spent, I'm going to say, almost quarter of a century, Vicky, I hope you don't mind me saying that, as a HR generalist. It was 24 years in the retail industry, so she has seen everything. She has an absolute lifetime of experience in disciplinary matters, in absence management, grievance procedures, recruitment, redundancy procedures, and training and development. So all the stuff that we get worried about in general practice that we're not dealing with, you know, as we should be sometimes. Richard's background and primary degree was in business. He's worked in Peninsula's Employment Advisory Service for 15 years, advising small and medium businesses on all aspects of HR, including conduct, capability, redundancies. He also has an advanced Level 7 diploma in HR Management and Development from the Institute, and is now a Fellow of the Chartered Management Institute. And he's currently head of Peninsula's Employment Law Training Division, amongst others. So again, has lots of expertise to share with us this evening. So without further ado, I think Kate and I are going to disappear from your screens, and we're going to hand over to Vicky and Richard.
Thank you, Claire. That's really kind of you to do the introductions for us.
So thank you. Good evening, everybody. Thank you for joining us this evening. Really appreciate it. I just wanted to start by explaining who Peninsula are. Some of you may already be in contact with us, going through some HR matters. Some of you may not have rang us before, but we are the leading HR advisory and health and safety consultancy within the UK. And we've actually been going for 40 years. It's our 40th anniversary this year, the business of Peninsula. So we're really proud of that. That's you know, quite a number of years there supporting our clients with their HR queries. We're actually a global business as well. So we started off in the UK, but we're also supporting clients in Ireland, in Canada, and also Australia and New Zealand as well. So, you know, thousands of businesses across the globe. And it's what we love doing. We work with small and medium-sized enterprises, as has been mentioned, but we also work with large employers as well. and we are really prevalent in the marketplace. So as a consultancy, we're actually delivering about 1 million pieces of HR advice each year, which is phenomenal, really, when you think about it. But that's over telephone and email, you know, any contacts there.
And don't forget, we can do video calls now as well, which is a service we can offer to yourselves as well. So if you did want to book a Teams call, for example, and have a video conference with us, we are more than happy to do that with yourselves as well.
Yeah, forget about the video conferencing. Advice that we provide is on a 24/7 basis. So it honestly doesn't matter whether it's the day, night time, middle of the night, you know, because we support so many clients across so many different industries, they require that 24/7 support. So whenever you need to call us, there'll be consultants available to speak to. And if it is a time when they're not on calls with somebody else, then we will always arrange to call you back at a time that's convenient for yourself.
One thing to just bring to your attention, the MDU group care account is located to what we call the priority team within the Peninsula Advisory Service. So you have a dedicated team of advisors that work between the hours of 8 and 6 that are fully familiar with the needs of your practices, of the requirements that you will have. Outside of the 8 till 6, when you've got your own allocated team, like Richard has just said, you do have access to the 24/7 out of hours service. So you have access to us on Christmas Day if need be, New Year's Day if you need be. There is always somebody there who is able to help with any urgent matters that you may find yourselves needing.
Yeah, we also handle tribunal cases for clients, employers as well. Last year, we had a success rate of 86% of all cases that we handled were handled to a successful resolution for our clients, which is a great number. And I think it's really just important to say that we partner with the MDU for yourselves. So, you know, we're there to support your practices and the HR matters that you have ongoing. Hopefully, you know, they're not as many as you would want, but you know, if anything arises, then we're there to support. So today we've worked with the MDU and considered the cases that we've been involved in terms of advising, and we came up with the agenda that's been sent out and advertised to you all. So one of the main areas that we work with surgeries and practices such as yourselves is with breaches of confidentiality and also inappropriate behaviour. Now that could be in work or even potentially outside of work as well. Also, we do get a lot of calls about staff absence. I think unfortunately absence is one of the biggest HR matters that's affecting businesses today, and it's something that needs to be addressed. So we do deal with a lot of those calls. We also wanted to talk about what we can learn from recent employment tribunal statistics. And we've also got a little section at the end as well, just to talk about the changes that are coming in the year ahead. Some of these will likely affect yourselves, and so we'll have a little discussion around those at that time. So I'm going to hand you over first of all to Vicky, and she's going to talk about the implication of confidentiality.
Thank you, Richard. So obviously it's really important when we think about confidentiality, not just in the realms of dealing with patient records, but also dealing with the confidentiality of individuals as well, making sure that we really do bear in mind that implied duty of confidentiality during employment. Really important here to mention that you will probably have a provision in your documentation, in your handbook, or even in the contract of employment that relates to confidentiality clauses. One thing that springs to my mind with working with the MDU and dealing with cases that get brought to our attention is that often there has been a breach in confidentiality whereby some information has been shared that somebody was not authorised to divulge. And it's really important here to think about, did that employee know what was expected of them in the course of their employment? So were they aware that they shouldn't access that patient record, for example, or shouldn't share a staff matter that had been confidentially told to them and asked not to share? So, you know, really, really important here to set the scene from day one with your employees as to what type of information you class as confidential and how they deal with that confidentiality. and also what the repercussions are of when confidentiality is breached. So really bringing to life your policies and procedures. It's really important that that is shared with them from day one. So if there is a breach, you can deal with it with confidence.
I would just add on to that, Vicky, actually, that when you call into Peninsula's advisory service, we will be asking you for details of what is listed in your policies and procedures. So don't be surprised if we just check what's in a handbook or maybe in a contract of employment regarding this matter.
Yeah, thanks for that, Richard. One thing that we know, if we haven't got access to your disciplinary procedure, we would ask you to send that through to us, just to make sure that we are keeping you compliant with that procedure. To make sure that you're consistent with the way that you deal with your employees within the practice. The other thing really to bring to life as well with this particular situation with confidentiality is that there are examples where breaching of confidential information can actually be cast as something called gross misconduct. Now, gross misconduct is where an employee behaves so badly that it really does strike at the heart of that employment contract, so that you lose all trust and confidence in them, and therefore feel that you can no longer carry on with that employment relationship with them. Gross misconduct is, it's the serious matters. It's right at the top level of conduct issues that you would be dealing with. And obviously, if you do find yourself in those situations, then please reach out to us, call the advice line, as Claire said right at the start, quoting that MDU 001 number, so that we can help you with navigating that particular situation. So, something that Richard touched on in his introductions in relation to Peninsula here, and just thinking about some of the cases that we've been involved in over recent times, is to do with employees being rude. One thing that springs to my mind in this particular situation, what would happen if, for example, a receptionist was rude to a patient, or there was an argument going on between the receptionist and another employee of the practice at that reception desk. So let's think about, we're not moving around enough, so our lights have gone off. So let's think about how we would deal with that situation and talk you through an example of how you would run a particular situation here. So I think we're going to talk about an outbreak of an argument on the reception desk to bring this to life for you in the very first instance. We've got to take into consideration here, what reputational damage does that cause to your practice? Is it, patients could potentially see this outbreak of the argument on the reception desk. It could be between two employees, which could create that feeling that it's a volatile in practice, that it's not friendly, and therefore could cause that brand damage to your practice. Also as well, that culture, that workplace culture, what is coming across from that little argument that's going on. Let's also think as well, you could receive complaints from patients from the fact that they have witnessed that argument within the workplace. They've come for a medical issue, they may be feeling nervous about relaying that information to their doctor, and then we've got this outburst on the reception desk.
Yeah, just looking at the next point, the seniority of the employee, it doesn't have to be an employee having an altercation with someone working at the same level. It could be a disagreement with the practice manager. It could be the practice manager, for example, issuing instruction to the employee who maybe doesn't feel they should be doing that. So those things do need to take into consideration when investigating.
Yeah, which brings us nicely onto one of those bullet points on that slide there about any mitigating factors. We are going to talk in detail about the investigation process that we would recommend that you follow when a matter of concern is brought to your attention. But it is really important to consider the circumstances and the context of the situation as well, to understand if there is any mitigation that has resulted in that potential outburst on that reception desk.
I think what I'd probably be asking as well, Vicky, is what the definition of rude is. I mean, we just said what if an employee is rude, but what does that mean? Does it mean that there's swearing or bad language involved? Does it just mean that they haven't picked up the phone when it's been ringing? Or have they actually entered into some kind of altercation with somebody in the practice as well? So it's really important to define what it is about the behaviour that you as employers feel is unacceptable or inappropriate or unprofessional within the practice.
Yeah, it's a really good point actually, and just to build on that, a recent case that I've been involved in actually related to a member of reception staff checking in patients, and in the back office the receptionist heard some giggling coming from the back office. It was a busy evening surgery, and felt that that was a really unprofessional situation to be occurring, because those patients who were waiting in the queue could hear people laughing, and felt that it was giving the impression to the waiting room that personal conversations were more were the highlight of the evening, rather than dealing with patients. And that particular receptionist got rather frustrated and shouted to the back office, "Is somebody going to come and help me?" which then potentially led to that reputational damage for the practice.
Yeah, I think it's a great example, and it's really important to remember that as employers, you can set the tone of what that behaviour is that you expect within the workplace. If you don't expect your staff to be having kind of personal conversations, within the workplace, you can ask for those to be refrained upon and to be had at either lunch or a break period. We've all got surgeries practices within our local towns and villages, and we're all, at the end of the day, we're all patients as well, so we all have that experience. I wanted to bring a slightly different example into this, Vicky, which is not necessarily an employee being rude, but other factors that were coming into effect that was making it look like the employee wasn't acting in an appropriate way towards the patients. The example that I supported the other day was that the nurse practitioner, sorry, it wasn't the nurse practitioner, it was a care coordinator, and they had been booking in appointments for patients. They were getting the appointments wrong. The patients were complaining about those appointments. One was for a baby who was supposed to be booked in for inoculations, was actually booked in for a flu jab incorrectly. And the care coordinator was also being very forgetful, so things that she was being given to do, she was forgetting to do, and then would get quite agitated. But the thing is that she knew that something wasn't right, and the surgery had worked with her for some time, and they were concerned behind the behaviour as well. Now, looking at a few of those points on that slide, talking about reputational damage to the employer, the impact that can have, unfortunately, this particular individual was impacting on the damage, impacting on the reputation of the practice they worked for. But they didn't want to just instantly look at, trying to get rid of the person because she'd worked there for some time. So what they ended up doing was discussing the concerns with her and just understanding how she was feeling, what she was thinking about at the time. And what we actually identified was that she cared herself about the patients and that she could see something wasn't right herself as well. So what might have started out to look like a conduct issue of someone or a capability issue and someone not doing the job the way that they expect it to be, but actually behind the scenes there was possibly a greater medical position to consider. And she actually went and had some blood tests done. Now those results we're still waiting on. But in the meantime, the practice was saying we're really concerned about her working within the practice, it's creating us more work than it actually is helping us. So our advice was to sit down with the employee, understand where she was at, empathise with the situation, but also make it clear to her the concerns that they had about her performance at this moment in time, and whether that might be due to something a little bit deeper. Now, she actually opened up and talked about the health of her father, and felt that she might be going down that same pathway. So it opened up a completely different, path to look at. And as such, we are waiting for blood test results. So on the face of it, something can look like one thing, but then, when you start to look into it, it can be something else.
Yeah. Which is why it is so important to really get into the heart of the situation, understand what is the story with that particular situation, which then helps you understand if there is any mitigation. And we are going to talk in detail about the importance of a good investigation to really bring to life what Richard was just talking through there with that particular example. Okay, so let's now just talk about what is the law on disciplinary procedures. So one thing that really underpins the processes and your policies and your procedures within your employee handbook is the ACAS statutory code of practice on disciplinary and grievance procedures. So we will talk about case law, which will also shape how we advise you, and also shape where you are legally bound to refer to particular cases, and therefore involve your disciplinary procedures. One thing that's really important, if we get it wrong, if we don't follow that guidance of the ACAS Code of Practice or case law, then there is the potential, if an employee did go to an employment tribunal, that any compensation that they get awarded could be increased. So it's really important that we do follow a robust procedure. So when I'm saying about potential claims at tribunal, what am I talking about there? So it's things like unfair dismissal claims, constructive dismissal. Constructive dismissal is a really interesting terminology because nobody is actually dismissed. Constructive dismissal is when your employee decides that they no longer want to be bound by the terms and conditions of their employment contract. They believe the way that you are treating them is so bad that they can no longer stay in that workplace. So it could be a health and safety risk. It could be the failing to consult with them on changes of terms and conditions. It's something that they believe that you have treated them so wrongly that they can no longer remain in employment. I'm also talking about discrimination. So if we treat somebody unfavourably because of what we call a protected characteristic, so age, race, religion, and one that you will always be very familiar with, disability. So it's about making sure that you know, we don't treat anybody less favourably because of a protected characteristic. It's unlimited compensation for a discrimination claim. So it is one thing we will always ask you about, and it's probably one, if those of you that have already accessed the Peninsula advisory line, that we will say to you, are there any protected characteristics you need to bring to our attention? Because we need to understand, is there that potential claim? We're not saying you can't follow a disciplinary procedure with them. It's just about making sure we take the necessary steps that protect you from those compensation claims.
Yeah, I just add in there, Vicky, that it is important to understand that we're not here to try and catch anybody out. We're not here to try and, you know, prevent you from doing what you want to achieve within your practices. It's just about understanding the risk, you know, and asking those questions so that we're aware. It might not be a factor, it might not impact on the procedure to be followed, but we do need to be aware.
Yeah, and you know, it's really interesting what Richard's just said there as well. One thing we want you to really feel when you start accessing the service is that we are there to help and support you. We will look to give you what we call a best practice option, but we will also talk you through what we would call a commercial option as well, which is where you can potentially take a shortcut through a procedure, but it will come with a risk, and we will talk you through what the risks are. But it's very much about working with you. We will ask you what you are trying to achieve. So if you are looking for a dismissal, then we're going to talk to you about how to get that audit trail in place to secure that dismissal safely and without risk. But equally, we will give you what we call a commercial option as well to assist you. The other thing that was on my mind when I was saying about risks as well is victimisation. Again, victimisation has unlimited compensation as well. So one thing that is really, really important is about the policies, your disciplinary policy and procedure that underpins how you act when you find misconduct occurring within the practice. It's really important that we do make sure we are consistent and we do follow your procedures so that we don't leave you open then to a breach of contract claim or that unfair dismissal claim.
Yeah, I think where we're looking at, we've just been talking about kind of breaches of confidentiality as quite a common theme that comes up, and that's, you know, quite understandable considering the huge amounts of confidential data that you hold and the access that people would have to that. And we've had calls, excuse me, about staff accessing files of patients who are people that they know, maybe even neighbours, family, friends. And that is you know, obviously quite unacceptable to be doing so. But when you call us and speak to the advisory service about that, we will be checking with your procedures about where this kind of breach sits. You know, have they you know, accessed something accidentally that they shouldn't have clicked on, or have they actually gone as far as to, you know, printing out a file or a patient's record?
Yeah, it's really interesting, that point, actually, when we start talking about questions to ask at disciplinary, it's about really understanding from that individual, did they know what they were doing was wrong, like Richard said, was it accidental, or have they knowingly accessed that information with a viewpoint to gaining it to worst case scenario, share with people out in the community. Okay, right, middle little block that we've got there is about allowing the employee to be accompanied at the meeting. So when it's an informal fact gathering investigation meeting, there is no actual formal right to be accompanied to a meeting. However, when we get into the realms of formal disciplinary meetings where we're inviting that individual to come into the meeting to discuss the allegations, then they do have that formal right to be accompanied. Normal rules and procedures as guidance by ACAS is that it should be a fellow employee or a trade union representative. I'm really mindful that a lot of the practices, you don't recognise trade unions, but you know, an employee could still be represented by a trade union representative, even though you don't recognise a tribunal. Little top tip from me on that: if somebody does say they want to be accompanied by a trade union rep, just ask to check the credentials when that person arrives at the site. They don't mind being asked the trade unions, they actually expect it. They carry a little credit card style identity document. Just check that it is, you know, that is that person and they are therefore a trade union representative.
Yeah, I think the question about the right to be accompanied can be a really interesting one. And we've had queries around whether someone could be accompanied by a fellow family member. Yeah. In normal circumstances, the answer would be no. But if that family member is working in the practice as well, then the answer would have to be yes, because Absolutely. They're a fellow employee.
Yeah, yeah. Absolutely. Another thing that kind of like sprung to my mind then when Richard was just saying that little situation to you is you may get asked to actually bring a family friend with them to a meeting who doesn't fit into the realms of trade union or a work colleague, and it could be because they have got a disability, maybe suffering with anxiety and depression, and they just want somebody there for that moral support. I would just recommend right at the start of the meeting really setting the scene as to what the role of that representative is. The last thing you want is a disruptive meeting that ends up with you know, people arguing potentially. We've had cases like that, haven't we, Richard, where and meetings have just become very disruptive. So always set the scene right at the start about what the role of a representative is.
And don't forget, you know, there's no question is too small. So if you do have a companion turn up with an employee and you're unsure whether it's appropriate to have them attend or not, give us a call on the advice line. We'd be happy to, you know, talk through those circumstances, find out who that individual is and whether it would be appropriate in the circumstances.
Yeah, you know, and don't forget, you know, you have got access to us 24/7. So, you know, early mornings, late nights, you know, we are here for you. Okay, right. So each stage, wherever possible, should be heard by a different manager. That is because what we need to demonstrate is impartiality, that there's been no prejudging of a situation, and therefore that decision has been made with that manager hearing that evidence. That again comes from ACAS Code of Practice and Case Law. So, you know, we recognise though in your situations in practices that, you know, there could be limited members of management. It could be that a member of your management is actually involved in the situation. You could actually be, you know, disciplining one of your senior members of the team as well. So we recognise that. And again, pick up the phone, talk to us if that becomes a concern of yours about who is going to deal with either the investigation or the disciplinary hearing. You know, we have got, you know, advisors who will help you navigate that situation. But we also offer something called a face-to-face service, whereby one of our consultants can come and help you hold those discussions and those meetings as well. Really, really important, the last section there of that particular side about informing the employee of the outcome in writing. I would always recommend, and it's just a personal preference of mine, is that you verbally give the outcome to the individual, especially in a disciplinary situation. I just think it's bad practice for a letter to drop through somebody's letterbox or to drop in as an email without you having, I just feel it's courtesy to give that outcome verbally to that particular individual and then back it up in writing. Also really important to back up in writing, because if you have taken formal action, they will have the right of appeal, which again comes from that ACAS Code of Practice and Case Law. So really important that we do back it up in writing and confirm who the point of appeal will be.
Yeah, thanks, Vicky. I think just referring back to the face-to-face service as well, it probably is important to note that that is an additional cost service, but definitely worth noting that that's available. And so certainly some of the surgeries that I've worked with, I know that they can be quite small, and therefore you might not have that same level of hierarchy that other kind of larger organisations have. So have been able to call upon a separate service to come in and support would be really beneficial.
And equally, it gets you back to your clinical work, which you are the professionals in that field, and leaves you to focus on that as well.
Yeah, we get questions quite often. One that comes up quite frequently is whether the same minute taker can be involved, because if you've got, you are limited on people that can be involved in those meetings. Can they have the same minute taker?
Well, actually, Richard, yes, they can. So really, really good point that Richard's just brought to the table there. So you can use the same minute taker throughout your investigation process, throughout your disciplinary, and throughout your appeal process as well. So they can attend all of those meetings. What's really important to stress here is that a minute taker is purely there to take the minutes of that meeting, to capture what has been discussed. They are not there to make any decisions. They should not be involved in any decision-making process. They are purely there to take the minutes. That way, you can absolutely use the same person throughout that process. Right, we're going to talk through now my favourite subject matter, which is all about a thorough investigation. This is my #1 top tip, and hopefully it's Richard's #1 top tip as well. A thorough investigation, it is crucial. It is the foundation of your disciplinary procedure. You get the investigation right, the disciplinary is actually the easy meeting to hold then.
Yeah.
Okay, so investigation is all about understanding what is the situation, is there a case to answer to. It's about making sure that we hold timely investigations, okay, so that we can take timely action. So capturing information when it is fresh in people's minds. We want factual information. We don't want hearsay. We want to understand, if we're dealing with a witness investigation, what have they seen? What have they heard? We don't want it to be about hearsay. Equally, when we're investigating with the actual employees in question as well, we want to understand, what does if we're talking about breach of confidentiality, what does that mean to them? What do they understand to be confidential information? Let's ask them what their knowledge is of the policy, of the procedures, so that we can really see, did they knowingly do this? Did they know what they were doing was wrong, and therefore there would be a repercussion of their actions?
I think that's an important point, is the understanding of the employee. And really, without a thorough investigation, it's difficult to establish whether the employee, at that early stage, whether they knew what they were doing or whether it was an oversight or an accident.
Yeah, it's really, really key. It's going to help you to understand where your investigation needs to be led as well. So you will meet with the employee in question who you believe has breached a policy. You may then need to open that investigation up to witnesses and to understand what they have heard and what they have seen.
I've just got a question to come in there, Vicky. Another one that gets put to us on the advisory line is whether a witness can actually remain anonymous.
Okay. Yeah, really good point as well from Richard there. So you can actually confirm to the witness that obviously we want to keep their information, that we will keep their information confidential. You will have some witnesses that are naturally nervous about, talking through the situation that they may have observed, that they may have been involved in. So absolutely, you can advise them that their name will be redacted from the minutes of the investigation. One thing to just build on with that, though, is if the employee who you are taking disciplinary action against puts in something called a subject access request, then they would get access to an unredacted statement. So at that time, they would then get to see whose witness statement it is. Also, if it ends up in employment tribunal, they're going to get to see who have made those witness statements. Another thing that springs to my mind as well is that the actual employee might be able to work out who that witness statement is from, even though the names have been redacted, just by the information that is being shared in it. But it is really important that to demonstrate a thorough investigation has been conducted, that we do take those witness statements, but really emphasising to your witnesses that we will do our utmost to protect confidentiality. And I think it's also worthwhile making a point here that if there is any repercussions, any where the employer then treats that person less favourably, victimises them, bullies them even, then there will be repercussions through that disciplinary procedures that you've got in your handbooks that would take effect in those situations.
Yeah, one thing that you can do as employers, if you are finding that employees are reluctant to come forward with statements about another employee, is to reassure them that you are there to listen to them, to understand how they're feeling about something. And the fact that it is important that it's dealt with, honestly, in my experience, there's nothing worse than brushing things under the carpet, hoping they'll go away, because they won't. And if anything, they just get worse and worse.
They do. They absolutely do fester and become a much bigger issue that can ultimately involve a lot more management time when you should be dealing with your clinical practices. You can find yourself based in lots of lengthy investigation meetings trying to establish the facts, which an investigation is literally that. It is about establishing the facts. It's about gathering evidence to understand, is there a potential disciplinary situation, an allegation to answer to. An investigation is an informal meeting. There's no requirement for a formal invite into an investigation meeting unless your disciplinary procedure actually says that you will invite in writing to an investigation meeting. Otherwise, you can literally just bring that person into that investigation meeting as soon as you possibly can and go through those questions. Another thing that I would say, get them to sign a copy of those investigation notes as well. You would not believe the amount of times that investigation notes aren't signed, and then all of a sudden when we get to a disciplinary procedure, the employee says, well, I didn't say that at my investigation meeting, it has been made up. And there is no signature on the bottom of it that proves that that was actually the content of that meeting. So always get signed notes when you're conducting your investigations. I think the other thing really to just say here as well about the investigation stage, the actual burden of proof is on you, the employer, to prove the allegation. It's not about your employee proving their innocence. It is about you getting to the heart of the issue and understanding, is there an allegation here? Is there a breach of policy of procedures? That is why it's so key to get that real thorough investigation conducted.
Yeah, I mean, I would say it's arguably the most important meeting as part of a procedure. And as Vicky mentioned earlier, if you have a good, solid, thorough investigation, it makes the disciplinary hearing so much easier, because everything's already been discussed, everything's already been covered. The disciplinary hearing is really the opportunity to bring everything together and give the employee a further opportunity. One thing I see sometimes, Vicky, is where we don't have signed minutes for an investigation, is that the employee will say something, you know, kind of admit to something maybe in the moment because that's the truth. And then you get to the disciplinary and they've had time to think about it and say, actually, that didn't happen at all. I got my information wrong. So it's important to have these processes.
I think equally, it's also important as well about the investigation. You might not actually end up in a disciplinary hearing meeting because the investigation shows that there is no case to answer to. For those of you that may have accessed the Peninsula service already, you know, we do have a cracking letter called a letter of concern that really does set the scene as to the conduct that we expect in the future. So for minor breaches, a letter of concern can sometimes be a really great alternative to actually going through a disciplinary procedure. But, you know, my advice to you is always think about, what has my investigation shown me? What facts has it shown? So therefore, what is going to be my allegation if I am bringing somebody into that disciplinary hearing? We've already talked through that investigations should be held by an impartial person, and also that we've got that minute taker present there as well. I always say take a minute taker. It allows you then as the investigation manager to really focus on your questions and the responses that you are getting back, rather than having to take the minutes as well. But equally, if you have got limited personnel in the practice, you could take your own minutes in that particular meeting as well.
Yeah, and you don't have to have lots of time to, you know, to give to the employee to hold that investigation. It can be done quite swiftly.
Absolutely, and I think that's really key, isn't it, Richard, about doing a really swift, timely investigation so that facts are really clear in people's minds as well. Yeah,
absolutely.
Okay, right, we'll move on then to our next subject matter, which is going to be about staff absences.
Okay, thanks, Vicky. So staff absences, as I mentioned at the beginning of the webinar, it is one of the, you know, hotly discussed topics in HR at the moment, and it's reported everywhere. What's really important in regards to managing staff absence is to have a really clear policy in place, and that will demonstrate how the organisation will manage. I always find that from a good HR perspective is that it's easy to manage employees and their actions if they know what the policies are in place. And in most cases, you don't need to take any action because the employee knows what they need to do.
Very similar,
Sorry.
isn't it? Having an absence policy in place to having a really robust disciplinary policy in place, and it's about making sure that you're consistent with the application of that policy as well, so that there's no kind of like misinterpretations.
Yeah, there is a lot of crossover in this actually. In the policy, you should be able to see, or an employee should be able to see, who they should contact and when. So if they are off sick, what are the absence reporting procedures? It's something that, you know, we receive so many calls on, is an employee not reporting their absence. So who do they contact and when do they contact? Do they have a telephone number of who they should contact? As part of the policy, do you allow or accept text messages or emails from your employees? Now, what I would say here is consistency is really key. What you don't want to do is fall into a trap of accepting text messages from somebody that you get on well with in the practice, but then, you know, expect other people to be ringing up. Fair treatment, consistency is really important.
Richard, what would we do then if somebody doesn't report an absence? What kind of a procedure should we follow? Is that a conduct procedure? Is it an absence procedure? What sort of procedure would we follow?
Yeah, it's a great question, because the failure to report in itself would be treated as a conduct matter. The employee hasn't done something that it's expected of them. Now, there is a question to ask though as part of that investigation: did they know what they should be doing in regards to reporting absence? And if someone's just started with an organisation and they haven't been informed of what the absence reporting procedure is, it makes it very difficult to take action at that early stage. You do need to inform them of the expectations.
Quite important then at induction to sow the seeds, isn't it, and really set the scene for how these absences should be reported and what is acceptable and not acceptable.
Yeah, absolutely. And as we well know, absences can range from very minor ailments to quite serious illnesses as well. So what that might lead to then is considering whether a welfare meeting is appropriate. So if the individual is off for a day, 2 days maybe, headache, you know, sore throat, you know, some kind of minor ailments there, then certainly a return to work meeting would be always considered, but maybe it might not be as necessary as a full welfare meeting. However, where someone, and again dependent on the amount of time that they might have had off, a welfare meeting could certainly be relevant.
What about long-term sickness then? When would we kind of like recommend that somebody is classed as long-term sick?
Yeah, it's a good question, Vicky. So we generally view 4 weeks as long-term sick. So if somebody is off for 4 weeks and likely to be longer than that, then we would certainly be there to support you with managing that long-term sickness absence. Now that can include things like obtaining occupational health and GP reports, and there's a sense of irony here that we're speaking to MDU members who, and a lot of you are probably very aware of employers writing to yourselves for reports regarding their employees' health, but you are also employers as well, so the same rules and procedures would apply to yourselves.
Absolutely, yeah, and I'm aware that when you're writing your GP reports, when other employers go to you about that application of the Equality Act as well, and those underlying health conditions and whether reasonable adjustments should be considered.
Yeah, absolutely. So return to work interviews and meetings, I can't stress how important these are. Every single absence, either even half a day, should be logged and recorded when the employee returns back into the workplace. Why? Well, it's really important to match the reason that they were absent through the reporting mechanism to the reason that they're giving when they return back into work. It's also quite difficult for people to be untruthful, I guess, if you're sat in front of them in a meeting. And so if they are trying to cover something else up, you can normally tell quite quickly.
I always think a return to work meeting is an investigation. It's an investigation into why that person felt so ill that they couldn't come into the workplace. So going back to what we were talking about on the previous slide, your return to work is your investigation into why that person didn't attend work. So again, a really key discussion.
The great thing about return to work meeting as well is that it also gives you the opportunity to catch up on things that the employee might have missed whilst being out of the workplace, and to keep them abreast of changes or new staff into the team, anything like that, even new briefings, updates that need to be aware of. Now, as part of your absence management procedure, you may have trigger points in place. Now, you do have to be very careful with using trigger points. It's really important that they're not just seen as a as an instant answer to the issue at hand, but they can be a useful way of triggering the managing of staff absences. Each individual and their reasons for absence has to be taken into consideration. There are various reasons why people may be absent from work, and there may be some mitigation to take into consideration as well. So a trigger point is exactly that. It's a trigger for a conversation, a discussion around the number of absences from the business, and it really is important to do something about it. I think earlier I mentioned about brushing things under the carpet, but you know, if someone's just off, you know, for a kind of minor ailment one day, and then a few weeks later it's another day, and then something else has cropped up, before you know it, it can actually amount to quite a bit of absence.
Yeah, interesting to look at any patterns forming as well, so that we can question at that return to work meeting the reason behind that as well.
Yeah,
and again,
absolutely.
that can help nip things in the bud, can't it? If the employee all of a sudden sees that you are seeing those patterns and recognising those patterns in their absences as well.
Yeah, it can. The return to work meeting documentation is really good for being able to spot and identify patterns. Now, what you might find then is that if an employee of yours is having a lot of absence from the business, you might need to instigate disciplinary procedures in regards to these absence levels. Now, you do have to be very mindful about the reasons for absence. They could actually constitute a disability. Now, the definition of a disability in terms of employment law is about whether a physical or mental impairment is having a long-term and substantial impact on someone's day-to-day duties and abilities of things that they do. Now, as Vicky's already made reference to, if something is identified as a disability and then we look to take disciplinary action because they have a disability, that could result in a discrimination claim. Yeah. And unfortunately, disability discrimination claims are uncapped at tribunal and can lead to very heavy compensation figures for clients. So we are very mindful of that. This is why, you know, we discuss with callers, with yourselves, about whether there are any underlying health conditions that we need to be aware of.
One thing we can look at though is reasonable adjustments and potentially increasing their trigger points. So their spells of absence might be listed in your documentation, that it would instigate a disciplinary hearing at 3 spells of absence. You might therefore want to increase it to 5 spells of absence and therefore safely manage that process because you have put that reasonable adjustment in place.
Yeah, brilliant, thank you. Now, we are very mindful of time. We are keeping an eye on it. So what I just wanted to really move on to is just that emphasising that importance of a return to work meeting after every single absence. It's great as an audit trail if ever it gets raised as an issue at tribunal, or maybe even a grievance that's been raised with the employee. And the other thing is that just saying that you've done a return to work isn't always enough in front of a tribunal judge. They do want to see evidence, and that return to work is evidence. There's also the importance of recording the reason for absence. If you don't have the return to work documentation, it can be challenged as to whether that was the actual reason for absence.
So again, it comes back to getting those notes signed so that there is no later cause for concern because somebody says that isn't a true reflection of what was discussed.
Yeah, reduces the risk of conflict.
Absolutely.
So with the tribunals in mind, I just want to pass on to Vicky to talk about the latest trends in employment.
Thank you very much. So just some really statistics just to bring to life for you here. So the latest employment tribunal claim numbers have been released. These figures that you can see on your screen now cover April to June 2023, and it's obviously compared to the same period of time in 2022. It's really important when you're looking at some of these figures that are on the screen now. 186% increase in failure to provide a written statement of main terms. Huge increase. Top tip here for you, make sure you issue that contract of employment ready for day one, ideally ahead of day one employment. So get into the habit of sending it out with your offer letters. If that's not possible, then as soon as they enter the practice on day one, get that contract of employment issued. It's going to really help you then with those claims certificates. So you're probably thinking, well, you know, what is the compensation for a failure to provide an employment contract? Maximum compensation is currently set at £2,572 per employee. It's not really a small amount, and if you've got 5 people potentially who all started on the same day, put in the same claim, then all of a sudden you're looking at, you know, potentially £12,000 there of compensation just because we haven't given them that contract of employment.
And don't worry as well, if you find that you have an employee who doesn't have a contract, issue it now.
Yeah,
Check
exactly.
the file.
Yeah, exactly. Do a little file audit in the morning, get those contracts of employment issued out. As soon as you've issued it, it takes away that claim statistic there, doesn't it, Richard?
Yeah, absolutely.
Okay. Right then, let's move on. So just really to talk through now some coming changes in the year ahead. So carers leave, that's going. One thing just to make clear just on this particular side, these policies that we've, sorry, not policies, these legislation pieces that we're talking about here, they've received royal assent. They are coming, they are definitely coming, but we actually haven't got dates when they take effect yet. So these are just sort of like watch outs, just have it on your mind that these are coming. Likely 2024 is what we understand at the moment. Yeah,
that's my understanding.
Yeah. So the Worker Protection Amendment of Equality Act 2010 has been approved. Quite a mouthful, that. I know, it's quite a mouthful. Has been approved by the House of Commons and the Lords. It has now got royal assent as well. Basically, that is all about preventing harassment occurring in the workplace. It is actually placing an obligation on yourselves, the employer, to prevent harassment in the workplace. Potentially a year away from that becoming legislation, but just have that on your agenda, that it's all about how you prevent. So any tips you can give, Richard, about that?
It's a real key piece of legislation for the government. There's been a number of cases that have been reported in the press, you know, through media, and unfortunately a lot of employers, you know, quite high profile employers as well, have been subject to claims of harassment taking place in the workplace. You know, the Me Too movement, sexual harassment.
McDonald's were one of the high profile.
Yeah, absolutely, and the BBC undertook their own investigation of that as well. So it is really important, and it's been seen and identified by the government. Hence the changes that are coming to effect.
Any of these policies that are on the screen now, again, feel free to call the advisory team, and we'll be able to help you and talk in detail about how those affect you. So flexible working, for example, obviously at this moment in time, it's one request and you have 3 months to deal with that request. So one request in a 12-month period and 3 months to deal with it. That is changing. It's actually going to kind of a day one right that you can submit a flexible working request, which is currently 26 weeks. And also you can request 2 changes now in a 12-month period. And you as the employer, you've got 2 months to deal with it. Also allowing time in that 2 months for an appeal as well. So
yeah, that's proposed. So please look out for details of when that is likely to come to effect. Again, we do expect these to be 2024.
Yeah. One thing that probably on your mind, just thinking about the medical industry at the moment, is that we are currently looking at the Minimum Service Levels Act 2023 in relation to strikes as well. So that's getting quite a lot of debate at the moment through the press. So we'll wait and see what comes out of that. But again, we will, you know, help and support you with any types of calls in relation to any of those changes coming in the next couple of months.
Yeah, I think one thing I just want to point out on that slide is that some of these things will be driven by not only the government bringing in the legislation, but you will be needing policies around these areas. So if you're not already thinking about it, start thinking about how you'll be able to incorporate these things not only into maybe a handbook or a separate policy or a procedure, but also how you might look to train your staff on being aware of these things as well, and the processes that will be required. I mean, for example, carers leave. You know, whether you agree or don't agree with the 5 days unpaid leave each year, what process will you have in place? We're not aware of the specific details of that as yet, but there will no doubt be a procedure to put into place.
Yeah, and about how you're going to record it as well, you know, to make sure that somebody doesn't have more than 5 days as well. So, you know, quite a lot of record keeping in all of these changes that are being introduced.
Yeah, payroll systems, for example, as well. You know, is it possible to record this kind of leave on a payroll system which has not been in place previously?
Yeah. Okay, so how am I going to prepare for the coming year then, Richard? You know, what sort of tips can we give our MDU clients tonight?
Yeah, so I think firstly, doing something like this is great. You know, tapping into the support, the resources available from the MDU is an absolutely great thing to do. But also use us as a partner to the MDU as well. So pick up the phone, or, you know, ask for a video conference call. You know, send us an email in regards to any queries that you have regarding HR or employment matters. Keep your eyes peeled. You know, you always see these things on the news. You know, or in the media, newspapers.
Yeah, just one thing actually, we do support the MDU as well with articles. So, you know, watch out in your journals. You know, we will be providing articles. You know, there is, you know, we will do a piece on harassment, again, to sort of like bring that to life, which we just talked through as well. So, you know, we are definitely working in partnership with the MDU. Please also use this as a sounding board. You know, it is a confidential help and advisory service for you. So if you know you need to scream and shout, then do it to us. Don't do it to your employees. Remembering back to the first slide that we talked through right at the start. We are there to help, support and guide you through your HR matters.
Great. I think we've got Kate that's jumped on.
We have. So Kate's now available just to close off just with some housekeeping right at the end. So I'll hand you over to Kate now.
Kate, I think you might be muted.
Yes, I was, sorry. First of all, thank you very much to Vicky and Richard for that really comprehensive and very insightful presentation. I'm sure everybody will have really got an awful lot out of that. Just to really highlight some of the benefits of group care, I'm a GP liaison manager. If you have more than 50% of your GPs in practice with the MDU, you can set up a group care scheme. You can potentially earn up to 10% on individual memberships. That's in England and Wales. We offer free membership for practice managers and discounted indemnity. And really what I wanted to focus on tonight is with group care, you do have access to Peninsula. You just need to quote MDU 001 followed by your group care number, and you have free access to employment law with Peninsula. And I'm sure that you will all have lots of questions, so please do get in touch with them. Thank you.
Thanks, Kate. And I would just really like to extend my thanks to Vicky and Richard for a really interesting presentation this evening. How I wish I had known some of this when I was a GP partner. I hope it's been useful to you. Please give us your suggestions for upcoming topics, and we hope to see you all again really soon. Thank you.